All persons having business before the Honorable Associate Judges now presiding of the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable court's now in session. Please come to order.
Good morning and welcome to the DC Court of Appeals in our virtual space. It is November 23rd and we have two cases on our calendar this morning. The first is 19 CF 117, Cardell R. Torney versus the United States. Counsel for Mr. Torney, if you would let us know how much time you'd like for rebuttal, and when you're ready, you may begin.
Good morning. May it please the court, Claire Pavlovic on behalf of Appellant Cardell Torney. I'd like to reserve 2 minutes of my time for rebuttal today, and I'd like to begin with our battle argument and then turn to Rule 16. The trial court abused its discretion in 3 ways by admitting 5 statements under the report of rape exception after the jury had already heard the complainant's immediate 911 call and report to the SANE nurse. First, the 911 call and medical report fully addressed Battle's concern that jurors might unfairly hold a rape complainant's silence against her by showing that she was not silent. She immediately reported. Second, piling on 5 additional statements made it a virtual certainty that the jury was going to use the number of statements as affirmative evidence that their substance was true. And third, the trial court's reason for admitting the statements as affirmative evidence of lack of consent violated Battle's directive that such statements are not admissible for the truth of the matter asserted. This case hinged entirely on the credibility of the complainant's claim that there was no consent, and the jury ultimately heard that she had said she was raped a total of 7 times to 6 different people. The government cannot show that it is highly probable that these statements did not contribute to the verdict.
Counselor, sorry, go ahead.
What was the evidence of consent?
The evidence of consent was essentially a credibility attack on her claim that there wasn't any consent, right? The government had the duty to prove consent. And here, the defense pointed to numerous inconsistencies in the government's theory, including the DNA evidence, which there were 2 experts who thought that it showed evidence of a second contributor, the 50-minute time gap in the government's story, which suggested.
I get the idea. I think Judge Easterly had a question.
I was wondering, counsel, if Mr. Torney is arguing that there should be a numeric cap, or whether you're arguing that in this instance, because there was sufficient evidence in the form of the 911 call and the SANE report, that the calculus of probative value versus prejudicial effect meant that the remainder of the statements shouldn't have come in under a discretionary analysis.
So our first argument is that no exceptions should come in under Battle once you already have an official complaint, because
it's sort of a one in, you're advocating a one and done rule. Is that?
No, we're advocating a no subsequent to official complaint rule, because the inference that Battle is supposed to be addressing is the inference that arises from a delay in reporting. And where there's no delay in reporting and the government is allowed to present evidence of that, then there is no need for these further statements. And we think that that is sort of the most straightforward and most principled way to manage this kind of evidence and sort of can keep Battle from metastasizing into a contest of who can tell the most people.
Let me ask you a question about that. Let's assume she places a 911 call quickly, and that fact is admitted into evidence. While the police are on their way, the next door neighbor comes over, sees her distressed, and naturally one would ask her, well, what did you see? And this she was distressed. She was, her clothes were disheveled. She had dirt on her clothes. There was some blood on her lip. It would seem very artificial, wouldn't it, to then omit any explanation of how that happened?
No, I don't think it would be artificial at all. The probative value of the neighbor's testimony in that instance would be about sort of what she saw at the relevant time, right? The only thing that a statement adds to that is the complainant's substantive claim about why she is upset, why she looks disheveled. And that is what's impermissible, and that's what's very damaging, and what was damaging in this case.
Can we just talk about you? So you led off by saying that there are really three aspects of your argument, and I'm most curious about the second. That I think you said that the jury would sort of take the cumulative strength of these reports as, you know, basically it's a harm argument, that they would take this as some evidence that he did it. I have a hard time seeing why. You know, these were all fairly all made within several hours of each other, all the same morning.
Yes, that's correct.
So, you know, if let's say there were 6 people around on the scene, and she says to each of them, let's say she says it, you could pick your hypothetical. She says loudly to all of them at once, "I was raped," or she says individually to each of them, each of the 6, "I was raped." Why does that make the first report more likely to be true? Why would a jury think that?
Well, I think that the jury is being told, you know, these are, you can use this as evidence that a report was made. In the context of just a single or even just a couple of reports, you know, you can see that going to this sort of distinction that Battle draws between the substance of the complaint and the fact of the complaint. But once you have a large number of reports and the jury is being told, well, you can use the fact of a report, the only way they're going to use that is the sort of the most natural understanding of that is a sort of repetition implies veracity. She wouldn't have said it to so many people if it wasn't true. And I think that, you know, our argument here is that once you reach a certain number of reports, that distinction that Battle hangs its hat on, that frankly is a very precarious one to begin with, when what you're talking about is a complaint of rape where the substance and the act are so intertwined. Once you sort of reach a cumulative amount of that, you know, that distinction really starts to fall away, and it just kind of goes back to being an inadmissible prior consistent statement. And I think that our argument in this case is that, you know, wherever that line is, and it's a line that numerous courts, including this one, have talked about existing, this case was over it.
Yeah, but I think right now, though, you're kind of pivoting back to the first aspect of your argument about whether or not more than one should be permitted. And let's just posit that I agree with you on that. The purposes of Battle are satisfied by one coming in, but I'm really but by one report of rape coming in, at least when it's, you say, official report. I'm not really sure how we define that. I don't know if the camp counselor in LC would meet that definition as you put it. I'm guessing not. But at least we know that a call to the police is an official report of rape. That would seem to satisfy the interest of allowing it in under Battle. I just don't understand why. And then she told 5 other people that same morning. I mean, you say repetition implies veracity. Does it? Do you think that's a natural place for, you know, if they had reason to doubt her, but she said it 5 times that morning, is that less reason to doubt her? I don't see why.
Well, at the end of the day, I mean, that's how the government was using these complaints, right? I mean, the government was saying you'd have to believe all of this was fake. You'd have to believe that she told this many people. And
where do they give me the citation where the government says, and you know she's telling the truth because she said it not once, but 6 times. Seems like a pretty flimsy argument to me.
She said that, I'm sorry, I do not have the page number, which I will give to you, but the government said the thing you don't do if you're trying to have a fling with somebody and you don't want anybody to find out, you don't broadcast it to everyone afterwards. You don't call 911, you don't tell the police, you don't tell detectives, you don't tell the SANE nurse, you don't tell your husband, you don't tell your parents, you don't tell people, right? So that is precisely how the government used it in its closing. And it's also, you know, it is, I think it is actually a very natural one for a layperson to make. I think as lawyers, you know, we're trained in sort of making these sort of fine distinctions. But I think to the average person, going around and telling a lot of people, you know, you might be telling one lie is one thing, telling a lie a bunch of times is another thing. And so, you know, I think that
Is there an argument, though, that the government's argument was in some way responsive to the defense that she had had consensual sex, but was worried about what her husband would think, and so reported it as rape, right? I mean, the reports almost support the defense case that she had to account for this incident, which doesn't make a whole lot of sense anyway, because her husband wasn't there. He was in Louisiana, right? But the defense argument was she thought he was going to find out, so she reported it as rape. No?
Yes, I mean, that was the defense theory, because the 911 call was there, and the whole question was, you know, why was she so upset that morning? And what these statements added, you know, was her substantive statement about why she was so upset. And I think, and that's the distinction, right? The defense said, yes, fine, she was upset, but we don't think she was upset because she was raped. We think she was upset because she was freaking out and wanted to hide what she had done. And
I think just if I can, as I hear Judge Easterly's question, and I have the same concern, so let me rephrase it as I'm thinking about it. If the defense theory is she's making this up because her husband's going to find out, and she doesn't want him to think it was consensual, so she's going to report a rape. In order for that defense theory to work, doesn't she need to tell her husband that she was raped as well?
I don't think that
But doesn't the report,
No.
I guess my
I mean,
question
no.
is, why doesn't the report to the husband bolster more than damage the defense? Without the report to the husband, the defense makes no sense.
No, I mean, I think the evidence was that ultimately the husband is present, is observing things, is the one who sort of provides what little corroborative physical evidence, physical testimony there is. I mean, he's thoroughly involved.
He's thoroughly involved after she calls him and brings him out. But so explain to me the defense theory without her telling anybody but the police. She calls the cops, says she was raped. Doesn't tell her husband, doesn't tell her mom. She keeps it to herself. In what sense does that act as a cover for her if her husband later? I mean, I just don't understand how that undermines the defense theory at all. It seems to be a necessary aspect of the defense theory that she tells her husband that she was raped. Without it, how does calling the cops lessen the risk of her being found out?
Well, at that point, she's covered her bases, right? So that if he does find out, she's saying, I called the cops. I said this was rape.
And I didn't tell you for several months because, that doesn't strike you that might lessen the strength of her defense?
lessen the strength of her, I'm sorry. I was just confused.
No, it's okay. It's a
Um,
confusing question. I guess what I'm positing is that, I don't quite understand what the defense is. If the defense is that she wants her husband to think she was raped, because if it comes out that she had sex with another guy, that's going to be big trouble for her. I don't see how that defense works without her informing her husband about it. She reports it to the cops. Husband's going to be pretty upset if he finds out 6 months later that, it's going to sound like a pretty fishy story if she never tells him.
And
Well,
by extension, she also has to tell her friends and, to sort of bolster this idea that this was not consensual. I mean, to cover up the fact that it was consensual.
Well, I don't think that, I think even supposing under Judge Deal's hypothesis that she would need to tell her husband, the additional 4 reports in this case, which the defense fought very hard to keep out. I mean, the defense didn't want these statements in, and the government did. The defense didn't want a bunch of prior statements about the very issue at being contested at trial. And so, I think the defense theory was she said this was rape because she was worried that her husband would find out she was having consensual sex. And, here are all the reasons to sort of doubt her credibility overall. And having a bunch of sort of affirmative statements in through other witnesses. I mean, that's why these statements are presumptively inadmissible in the first place.
Are you saying that sort of this defense theory was kind of settled upon after this issue had been decided adversely to the defense? I mean, this is all litigated pre-trial.
Yes, this was all litigated completely pre-trial.
Do you want to move on to your Rule 16 argument?
Sure. First, I'd like to explain why the SANE nurse is part of the prosecution team, and then I'll turn to why sanctions were required in this case. The SANE program is a critical partner in investigating and prosecuting sexual assault in the district. They are the entity designated to perform all SANE examinations and partner closely with MPD to ensure that important evidence is collected and stored for use in prosecution. When they collect evidence in this manner, they are acting as part of the prosecution team and subject to the same Rule 16 duty of preservation that any other agency would be.
So that makes sense to me. And I'm wondering whether you are arguing for a rule that just look, a SANE nurse, when a complainant goes to the SANE program, I guess it's now the DC Forensic Nurse Examiner program, and consents to a forensic exam, that material is Rule 16 material, or do you have kind of broader criteria for what the prosecution team is under a Rule 16 analysis?
No, I think our argument is that when the SANE program acts in this capacity, that fits very squarely within the existing concept of what an entity covered by rules subject to Rule 16 is.
Well, I mean, I guess one of the things that sort of surprised me reading the briefs is that there's just not a whole lot of law on what the prosecution team means, in particular in the Rule 16 context. And so I'm wondering, would it be helpful for a case to explain that, you need, that it needs to be a governmental sponsored entity, that it needs to be funded by the government, that it needs to, have an investigative purpose, sort of, or is it just that we should be recognizing that this exam in this case on these facts was conducted by a member of the prosecution team. I'm looking for sort of more general criteria, if you think any such criteria exist, because I didn't see any in the law as it.
I think that right. Now I understand your question. I think that the test is and always has been. I mean, it's the same test that you have under Brady. That in Bryant, what the court is relying on for its the proposition of the idea of the prosecution team is in fact is Brady itself. That's what it cites, and that's a very functional analysis. And I think that you can call from the case law that exists, although I do think that it could use some clarification, that what that means is the agency, is the entity sort of doing the kind of investigative work that typically sort of falls, typically the police would be doing, right? It's about how closely intertwined they are. So, the fact that it is a government entity or a government sponsored entity is obviously going to matter. But I think at the end of the day, it's a question about how they are acting and why they're acting that way. And the trial court here, found that they're acting for the purposes of prosecution, and that I think to our mind is really the test. Or is the sort of meat on the bones of the functional test.
Can I shift to the question of sanction? I didn't see in the record, and maybe I missed it, any argument that that the defense was requesting. I didn't see any request, in the transcript for a sanction based on the loss of the clothing as opposed to the photographs. Am I mistaken?
Yes, you are. And I apologize, I don't have that citation at my fingertips, but it's in the second. There are two different sort of legal discussions that happen with this. There's the.
So what is you can give me the record site when you get back up for rebuttal, but what was the request for the sanction vis-a-vis the clothing?
Right. So vis-a-vis the clothing, it was the same sanction that was requested, that the sort of the photographs at the end of the day just be stricken, because.
Okay.
Well,
so just by virtue of not preserving the clothing, they want the testimony from the forensic nurse examiner to be stricken, but not any testimony about the clothing to be stricken.
They didn't make that specific request, but in the sort of second day of discussions, they say, we want to clarify that our requests and our arguments include the loss of the clothing and include.
So I understand that they thought that the loss of the clothing was a Rule 16 violation. I just didn't see a sanction related to the clothing.
Yes, I think the sanction that they wanted was about the photographs and.
The other record question I have is, I didn't see that the court ruled on, they have alternative requests, either strike the testimony about the photographs or give us a missing evidence instruction. I mean, maybe it's implicit in the court's ruling, but I didn't see the court rule on the request to strike the testimony about the photographs. The court just says, I'm not going to give a missing evidence instruction.
Right.
So what's your position on that?
I think it's implied in the ruling. The defense certainly made the request. I think that when the government came back and the defense made its request and arguments orally, the government filed a written opposition, and in its written opposition, it focused solely on the missing evidence instruction. And so that may be why that was, sort of how the trial court framed it, and sort of didn't go out of her way to make an explicit rejection of the other request. But the defense was very clear in its request to the judge that it wanted the testimony about the photographs stricken. And
all the testimony or just the nurse forensic examiner's testimony? Because I thought it was the latter.
Yes, the latter.
Confused me because the complainant testifies about having her photograph taken. I mean, in the course of saying this is a very invasive exam, she talks about having photographs taken, but that testimony was not, there was no request to strike that testimony. Am I correct?
No, because the problematic testimony was the same nurse's sort of explanation of that the reason, sort of part of the reason for her deficiencies was that she just assumed that all of this evidence would be captured in the photographs. That's why the defense was focused on the same nurse's testimony about the photographs and not the sort of incidental testimony of the complainant.
My final record question is, I also didn't see any kind of real discussion of gross negligence or a finding by the trial court. It seems quite a mystery, kind of how or why the photographs got lost. The government makes a proffer about, records in the cloud being moved to a different cloud. It does seem clear that if you credit the complainant's testimony that she was photographed, it seems like there were photographs and we have no idea, right? I mean, it's hard to say gross negligence on this record as matters stand if we don't know, were they uploaded and then lost after they uploaded? I mean, if this is some sort of octo flub because, files got lost in transfers between the cloud, do we really count that against the nurse forensic examiner or the MPD for that matter? I'm struggling with the gross negligence argument.
So here, the burden is solidly on the government to explain the loss of evidence, and the government made almost no attempt to do that. And in fact, they're the only, and the reason they have that burden is because they're the parties who are in a position to find out. And instead, what they offered was a lot of sort of speculation. And in Robinson, this court said, speculation doesn't cut it under this analysis. And, if you can't provide an explanation, that is at least negligence. And here you have negligence about two very critical pieces of information, that there were two parties who should have been responsible for it being preserved. And I think that this situation is very much like Smith, where there's evidence of obvious importance that multiple people are not taking care to make sure that they're preserved. And the government hasn't provided us with any particular explanation. And I think under those circumstances, I think given the importance of the evidence, it's quite fair. And I think that is Smith's analysis, that is gross negligence. There was
just a lot more information, right? In Smith, there's no question the shorts are taken and given to the Department of Corrections, and that's where they are. And then they are destroyed after 30 days because they weren't collected, or they're within some period of time, they are destroyed, right? So we kind of know, right? But here, just the photographs, we think they were taken, maybe they weren't even taken at all, but we think that they were they uploaded? We think that the nurse examiner says, this is what I do. I upload them to a sane server, but they aren't there, right? And why they aren't there, there's no policy that they get destroyed. And I didn't really see any attempt by the defense to kind of put the government to its burden, but maybe that's burden shifting to say that the defense has to say, look, they have to prove that it's not gross negligence. Or I guess I'm wondering, are you saying we should assume gross negligence unless the government proves otherwise?
I think that under these circumstances, the court has to find gross negligence because it is in fact the government's burden. And we're talking about two very important pieces of evidence that would have been, there's nothing subtle about the importance of this kind of evidence. And you have two different government actors who are not doing what they're supposed to be doing to make sure that these things are preserved. And so I think that it is the government's burden to explain why this is missing. The defense is absolutely not in a position to do that. And they didn't do that here. And so that burden or that failure to meet that burden counts against them.
Can you describe for me your theory of harm as against the alternative request for an instruction that they don't get to reference the photos being taken? And I'll put it this way. In one universe, the nurse takes a really sloppy written report and really sloppily loses the pictures that she took without explanation. In the other universe, she takes a really sloppy written report and there's no mention of pictures. They're not allowed to get into that. Those two strike me as sloppy nurse mucked up all the evidence and now we don't have it. In both situation A and B, they look sort of the same to me. So why do you think there's a reasonable probability that under scenario B, they don't get to mention that they took pictures? That's somehow going to inure to the defense's benefit?
So there are two reasons. The first is that as to the evidence about the sort of nature of the injury, the defense called an expert to say this is a wildly deficient report. And one of the things that's problematic about it is that it's missing all of this relevant information about this injury. And the same nurse gets up and testifies, oh, well, if it didn't look fresh, I would have written that down. And she then goes on to say, I guess I didn't write this stuff down because I thought the pictures would be there to prove it. And so she's sort of vouching for herself beyond what's in her report in that instance. And then on top of that, when you look at the clothing, it's a similar issue, but it's a little bit nuanced, which is that on its own, losing this clothing looks really bad for the government and sort of at least suggests a negative inference about why it was not preserved. But the government was able to use, and the same nurse was able to use another piece of missing evidence, the photographs, to sort of provide an innocent explanation for why that clothing was missing, which was, oh, well, I must not have collected it because I thought, the photographs would be there to prove it. But she had no memory of the exam. So she's just sort of speculating there, and it's allowing the government to, counteract that very negative, powerful negative inference by using another way in which, it was deficient. And so we think that's very harmful. It's on the question of harm. This was not this sort of exceptionally strong slam dunk government case. The first two analysts who looked at the DNA evidence found it was consistent with two male contributors, which provided a real reason to doubt the complainant's testimony. So much so that the government called in a third expert to rebut its own previous two experts. Then you have this 50-minute time gap, which also provided a reason to doubt and fit particularly nicely with the defense theory. And the jury was clearly grappling with those things because after 3 days of deliberations, it sent a deadlock note. I'm sorry to interrupt, but I had a question. I didn't see it in the record. Do we know what time the bar closed? Sorry. There was a lot of evidence that they left around closing time. Yes. And so I'm wondering if there's evidence in the record about what time the bar closed. No, the only evidence is Ms. Houston's recollection that it was, sometime between 1:30 and 2:30. That's it. If the court has no further questions, I will save the rest of my time for rebuttal.
Thank you, counsel. We'll give you a couple of minutes. We'll hear from the government now.
Thank you, Your Honor, and may it please the court, Brian Hahn for Appellee of the United States. I did want to start with the Rule 16 issue, and the judge in this case did not abuse her discretion in declining to impose sanctions, the requested sanctions on the government in this case, for any alleged Rule 16 violation. First, because the SANE nurse and the SANE exam are not part of the prosecution team, and therefore there was no Rule 16 violation. And second, even if they are part of the prosecution team, the court did not abuse its discretion in not imposing the sanctions that appellant requested. Judge Easley, I think you muted
Sorry.
yourself.
I did, right before I started talking. Why does the government think that the forensic nurse examiner wasn't part of the prosecution team? I mean, you know, I understand that they can do medical exams, but clearly in this case, this was a forensic exam. And, you know, she had the complainant sign a release that said, I understand that this information will be used or disclosed to the following people or entities to accomplish the purpose stated above, right? The purpose stated above is for the purpose of investigating if a crime has been committed, and if so, prosecuting the individual responsible for the criminal behavior in accordance with the criminal statutes, right? Interesting, it says for the state of Virginia. But in any event, it's clearly for a criminal purpose, and it's going to be disclosed to the crime lab, to the MPD, to DFS, to the U.S. Attorney's Office. How can the government really persuasively argue that the forensic nurse examiner was not acting as a member of the prosecution team? I mean, set aside all of the, you know, general orders or, you know, special orders about the relationship with the MPD and what happens with the evidence. And it seems pretty clear what the forensic nurse examiner knew what he or she was doing in this case.
So I think that the question here is the matter of who the nurse and the SANE exam is serving in any given instance, and in this case in particular. And what the SANE program and the SANE nurse are doing is that they're providing a service to the victim. So they're providing both the medical service to the victim, of course, which is the primary purpose of the exam. And then they're providing a service to the victim that if they want to participate in helping a prosecution in the case,
right? Wait,
they can
I mean,
collect.
I already posited that there certainly is a medical purpose. I'm not sure that I would say it's the primary, but it is a coexistent purpose. But in a case where you have a complainant who signs this form that says, this is what we're going to use this information for, what I want the government to answer is why in that scenario, right? Like if the alleged victim complainant does not sign this form and does not consent to the exam for this purpose, different scenario perhaps. But in this instance where the examiner has made clear, this is my objective, this is why I'm doing these tests, and the complainant says, okay, I agree to you, examining me for this purpose, why is the forensic nurse examiner not acting as part of the prosecution team?
I think I'd point the court to Weems in that case, because it's clear that private actors, even though they do some work investigating a crime that
The
occurs
forensic
and
nurse
handing it over
examiner
to
is not working at this juncture for the hospital, right? She says, I'm on a different shift, right? I'm on my SANE shift. And who pays for the SANE shift? The DC government pays for the SANE shift because it's part of the sexual assault response team program, right? The Office of Victim Services hands out grants, right? This is all on their website that is cited to us. That's where the money comes from. That's who's paying her to do this. And who set up the SANE server where all this information is getting uploaded? Presumably the government, right? That's not a private server. So this is not for the hospital, and this is not for medical care. And this is not a purely private entity, right? This is a government-sponsored program that exists to make sure that people can be prosecuted, that forensic evidence can be collected for the purpose of prosecution.
And what I would say is that part of this, the sexual assault response team, of course, is NVRDC, which is not a member of the prosecution, is a victim advocate organization. I think that the SANE nurse program and the SANE nurses here are in a similar role, that they serve the victim first and foremost and are agents of the victim. And the reason why they have an explicit release form that allows the victim to choose whether or not the information is going to be handed over to the prosecution is because they're required to by law. They need either the victim's permission or, and we talked about this later in the record, the government needs a subpoena to get medical information from the SANE program or the victim's permission. And that's why that explicit release is there, because
I
they
don't
need to make
understand
sure
what that has to do with what the forensic nurse examiner is doing. Okay, fine. I mean, it's sensitive information, and so the government, the U.S. Attorney's Office or the MPD has to subpoena it. But the forensic nurse examiner already has consent from the complainant to do this invasive examination for forensic purposes, to turn it over to these investigative and prosecuting entities.
Well,
And the
they do it.
complainant knows that. So I mean, that's where I started, and that's kind of where I'm still stuck. I haven't really heard an answer. Do you want to move on to the sanction issue?
I'd like to ask a question before we do. If this program is, as you say, Mr. Hahn, focused on the victim, why are there general orders and special orders promulgated by the police department?
So I think there are general orders and special orders promulgated by the police department. So because the police department recognizes that one of the, it's better to get this evidence through a medical professional than it is to have a detective or a crime scene technician try and obtain this evidence. And so we have said, when this happens, this is what the SANE nurse in the program, this is what their role is. This is what they do in these instances. And
so the orders are meant to curb or rein in aggressive detectives and police officers?
I mean, I think the orders are only directed towards the police. The orders do not purport to tell SANE nurses what to do or the SANE program what to do. You can look at the orders that appellant provided that were there, and they say that, that they say all sorts of things about what the detectives shall and shall not do, but they only describe sort of descriptively what the SANE program and what the SANE nurses do.
Can I just ask a hypothetical? Let's say that the police officers often avail themselves of a group of private interrogators. The DC private interrogators. We've got a suspect, and the police will drive him down to the private interrogators and let that interrogator go ahead and have a crack at him, figure out what he can figure out. Does that strike you that those private interrogators would be a part of the prosecution team for purposes of Rule 16 and Brady disclosures?
I think it depends on the relationship between the police department and those private interrogators.
So feel free to map on all the relationships that we have here. The private interrogators are paid by the DC government. I guess that makes them non-private, but that only makes the hypothetical a better one for the government than the SANE nurse. So what more do you want to know? I mean, it strikes me that based on those facts, you know everything you need to know to say that those interrogators need to, the government's going to be responsible for what they learn. They have facilitated it, they have propped it up, they have ushered the suspect to those interrogators. And if the answer is, well, it depends, and there's a way to get around disclosing anything that comes out that's favorable to the defense in those interrogations, man, that seems like a really bad result.
So I think there's two things that are present here that aren't really an issue, I guess, or at least would never come up in this sort of scenario that you're positing, Judge Deal. And the first is, of course, that we've been talking about the access that the government has to the information. And again, at least in terms of the photos here, for example, the government did not have access to those photos without either a release from the victim and a request with that release or a subpoena. And so, as Weems says, this is not a case where the government let the evidence sit in the hands of another agency, had access to it and used it to prepare for trial. It's that the government couldn't get access to it, in fact, until at least
Yes,
if there
I
were
find
photos
that
taken.
really,
they were
I find that
lost.
argument kind of confusing, right? Because the government does have access to it if it has the complainant's consent, which it did here, right? It's not like that information is accessible to the general public, right? Like I
So-
couldn't go to the hospital and say, well, they, there's a consent, here's my consent form, get this person to sign off on it and then give me the results as a private citizen, right? Like, yes, this is medical information as well as forensic information. And so because we respect the rights of putative victims, we get their consent. But once we have their consent, then yes, the government absolutely gets this information, right? Like, and all they have to do is get the consent, and they did get the consent. And so they have the right to access this information, but that still is diverting from what the nurse forensic examiner is doing, right? And the nurse forensic examiner, right? We're not talking about custody or control by the police. We're talking about custody or control by the nurse forensic examiner as a member of the prosecution team, right? And what is the nurse forensic examiner doing? The nurse forensic examiner is gathering forensic evidence, which is exactly what she told the complainant she was doing.
I guess I have just 2 points to that. The first is that I do believe that the defense could, in fact, either obtain the defendant's consent and obtain pieces of evidence from the same program, or they could get a subpoena, and if they had a valid subpoena, they could get it. But in terms of whether or not I'm sorry, no, I just blanked for a second.
Does the record, or do you know what result if the complainant says, no, do not disclose that? Does the SANE exam go forward?
So the SANE exam, I don't think it's in the record exactly what happens. The nurse did testify that the forensic service could not happen if the victim said, don't collect any of the things. I do know that the practice is that, and I don't think this is in the record, but the victim can even get the SANE exam done, the forensic portion, and to have the materials not be turned over to the police or the prosecutor.
I'm sorry, repeat that.
So,
I misunderstood.
Sorry, I know that the victim can elect that the forensic portion of the exam be done and choose to have it not be turned over to the police.
Okay.
I don't know if that's in the record, and I suspect I don't think it's in the record. What we do have is the nurse saying that the forensic portion doesn't have to be done. So I think, in terms of the in terms of whether or not, I think going back to Judge Easterly's question, it's that part of what determines whether or not the agency or individual who is acting as part of the prosecution team is the government's control of that person and their access to the evidence that person collects. And I'd point to the court.
You cited a case from the 10th Circuit or something for that proposition that the prosecutor has to have control, sort of like supervisory authority over every member of the prosecution team. I'm not sure that we've ever interpreted the prosecution team that restrictively in any context. And as I already discussed with Mr. Torney's counsel, our law on what the prosecution team is in the Rule 16 context is pretty sparse. So why should we adopt this kind of supervisory authority concept of prosecution team?
Well, I think if the question is, what is the prosecution responsible for turning over and knowing about, especially where, as you discussed with Mr. Torney's counsel, the obligation for showing why evidence was lost is on the government. If the government cannot obtain that information or needs to go through, very specific and legal processes to get
they
that.
can get the information. That's my point, is that the whole raison d'etre of the SANE program is to facilitate this information flowing into the hands of the MPD and the prosecutors. That's why we don't have people going to get sexual assault examinations from any medical care provider. It's why the MPD says you can go and get a SANE exam at the Washington Hospital Center, right? That's where these things are done. We encourage you to go there. And the stats show that the 95+% of all sexual assault exams are in fact conducted there, because the police funnel people there and people get those exams, and then that information goes into the hands of the prosecutors. It just seems like the rule that you're suggesting that we adopt would sort of promote maybe turning a blind eye to entities that you wouldn't have supervisory control over, but that full well exist and are operating to your benefit. And that seems like a bad rule. We want everyone who is participating in this evidentiary endeavor and this investigative endeavor to be working hard to preserve evidence, so we make sure that we have the forensic evidence to make sure that the right people get prosecuted and convicted, right?
I think that's right, Your Honor. But I would point the court to Weems again. And, in Weems, the Walmart security guards there, they actively
The SANE
participated.
program is just nothing like a Walmart security program. I mean, the SANE program exists for the purpose of collecting forensic evidence, right? The Walmart security program exists to preserve Walmart's profit margin and make sure that people aren't, stealing from the company. It's just a completely different scenario. I don't think it's analogous at all.
And I guess I disagree that the SANE program is either, again, primarily or only interested in prosecution. I think that the SANE program, as testified to by the nurse in this case, and as the website cited to the court by appellant, it's victim focused. It's focused on providing services to the victims.
Do you want to move on to the sanction question?
Sure. If there are no other questions about that, in terms of the sanction, I think the trial court did not abuse its discretion in declining to sanction the government as appellant requested. First of all, because in this case, the degree of negligence by the government was just negligent at most. Second, because as the court recognized, the importance of the evidence that may or may not have been lost, we're talking about these photographs, was minimally important. And third, because the evidence of appellant's guilt in this case was strong.
The second one seems like it strikes me as being quite important. What her clothing showed, could have verified or undermined the version of events that she told, right?
So I think, and I think that the trial court was focused on the photos of the injury, which, as appellant's expert testified, would not have reflected whether or not she consented.
They respond that, if it wasn't fresh, it would have provided some evidence. But let's stick to the clothes for a second.
Sure. I think that, this court has said multiple occasions that if there are alternative things that show what was in whatever evidence that was lost, that it's not as important. And I think that in this case, the SANE exam nurse did note in her report that there was dirt on the clothing, and that separate evidence of what the victim's appearance looked like and what the clothing looked like serves to make the photos less important. Not to say that the photos weren't.
The quality of the SANE report was squarely attacked, right? I mean, the defense put on an expert to say, let us tell you how this report is deficient in X many ways, right? So to say, oh, well, let's look to the report, it has sort of a circular quality of, yeah, sure, they lost the photographs and they lost the clothes, but let's look at the deficient report to show that none of that, that matters.
Well, I don't think that the criticism of the SANE nurse was that the things that she wrote down and the things that she did note were incorrect. I think that it was just that she did not provide as much detail as you would expect a good SANE nurse to provide. And so just because that there wasn't more information on the report doesn't mean that the information there was somehow not appropriate or not good enough.
This is probably an unfair question to ask, but do you want to explain to me why the strength of the government's case should matter to whether or not, I know that's our precedent, why that should matter to whether or not a sanction should be imposed? I mean, it seems quite counterintuitive to me that the overall strength of the government's case, if it's very strong, sort of when the defense might most want a sanction, they don't get it. If it's weak, well, then you can get it. That to me, I would think would be immaterial. But have we explained why the overall strength of the government's case should matter as to the sanction?
I don't know the answer to that question, Your Honor. It might be that it's it's a long line of cases that go back discussing what these are, and I don't know that anyone in this case has looked that far back to see
that's a fair enough answer.
So I apologize, I can't answer that question. But I will say, the evidence of the guilt also, of course, reflects upon the harmlessness of the error. And even if the court should have imposed sanctions because the evidence of guilt was strong, that error was harmless. But I think in particular, I know that we haven't talked a lot about the missing evidence instruction. I think that it was not error to, or not an abuse of discretion not to give the missing evidence instruction, especially where the nurse did, the evidence was against the inference. I think that because the nurse noted that there was dirt on the clothing, that acted against the inference that the evidence was destroyed or lost for nefarious purposes. And there was no, and the fact that the evidence could have been exculpatory was entirely speculative. And I would just note, sorry, go ahead, Your Honor.
I was just going to ask if we could address Battle briefly.
Yeah, and I just note that the court, I don't think the court has to, if the court thinks, because the trial court didn't abuse its discretion in imposing no sanction, the court doesn't even have to reach the issue of whether or not the nurse is part of the prosecution team or not, if that's the case. Moving on to the Battle issue, the trial court in this case also did not abuse its discretion in admitting the reports of rape in this case. I think for a couple issues. The first is because as Battle says, there are three reasons why we admit this kind of evidence. The second being that it negates prejudices, showing jurors that the victim behaved as jurors expect a sexual assault victim to behave. And I think you'd expect.
Do you think that we actually, I thought at one point reading the government's brief, but now I'm hearing you say this, that you don't actually look to what the justification, we had certain justifications for the Battle exception to prior consistent statements, right? But that was just the foundation for the rule that you can put in these reports, that you don't have to actually have those justifications active in the particular case where the prior report is sought to be admitted. But is the government arguing to the contrary? Like, does this have to be an actual act? I thought the government's argument was, look, this is just societal expectations and we don't know who our fact finder is. And so Battle says you can put in a prior report. So we get to put in a prior report. We don't have to verify that the particular justifications for Battle exist in the particular case. Am I wrong?
You're right, Your Honor. I guess I've jumped ahead because I think, that when that happens, of course, the reports of rape are admissible, or at least they're admissible under Battle. And then the question becomes, I think, whether or not they are more unfairly prejudicial than probative, because the 403 balancing test always applies in those circumstances in any admission of evidence.
You just said reports plural, and I guess I'm wondering why, after getting in a report, a 911 call, why you need anything beyond that, or to put it in probative value versus prejudicial effect terms, why the probative value is anything more than de minimis, because you've already fulfilled the Battle purpose, but with admitting the report of the 911 call, and why the prejudicial value from, repetition, doesn't outweigh that de minimis probative value.
So I think that the probative value isn't de minimis, especially in cases, and this is sort of alludes to what I was saying before about negating prejudices that show about the jurors expecting, or society expecting, how the victim to behave. And I think in cases, especially like this one, which is a stranger rape outside, that the victim is, I think society expects that the victim would report that to not only the authorities, but also to close friends and family. And that's exactly
that's not Battle, right?
Yes. If the question is really, I think the answer is yes. And if it is Battle. I think Battle says.
Nobody has been sexually assaulted who wouldn't immediately tell their friend. And if she didn't tell her friend, then I don't believe it. You think that is a natural societal assumption?
I think that it is one of the societal assumptions. I'm not saying that it's not an unfair one, and that's why Battle exists. But I think
we get these societal assumptions from anyway? I mean, what's the foundation for that one? Because I don't see that one in Battle. I mean, I think the foundations for the societal assumptions in Battle are also questionable. But this one seems different than the ones that are in Battle, and I'm not sure where we're getting it from.
I think I'd point the court to the main case, Family, where there was a report from a child sexual abuse victim to the child's mother. And even though that wasn't the first report in that case, that report was allowed because you'd expect that a child would tell their parents about
what was the first report?
Assault. I actually don't know what the first report in that case was, Your Honor. I don't believe it was to the police. I think it was a disclosure to someone else.
I think that sounds like a quite distinguishable factual scenario. I mean, here we're talking about a grown woman and whether or not the fact finder needs to hear that she reported not just to a 911 operator, not just to a forensic nurse examiner, but also to a detective and her spouse and two friends before they can actually trust that she is telling the truth. And I'm just wondering what is the foundation for that in Battle?
I mean, again, I think that it's just negating the societal and juror prejudices. But I mean, the second, reason why it was admissible, of course, that the trial court recognized is that it's there to provide context for demeanor evidence. And so it's important, it's independent evidence, as this court has said in Garibay.
So, I mean, here's my hypothetical, right? I call someone and I am hysterical on the phone, and it's not an excited utterance because I'm talking about something that happened 2 weeks ago, but because you want to put in the demeanor evidence that I'm hysterical, you can get in the statement that's not an excited utterance as context for my demeanor. I mean, is this how we get in hearsay these days?
I mean, I don't think that's how we get in hearsay, Your Honor, because as the court instructed the jury in this case, they weren't to use the reports as substantive evidence. They were only to use them as evidence that the report was made. And I do think that it's
How might they
important
have
to-
done that? Explain to me what probative value the report has if it's false. So if demeanor is important, independent of the hearsay value of the statement. So she says, I'm raped, and demeanor matters, but it only matters to the extent it corroborates the truth of what she's saying. If demeanor matters independent of the truth of the statement, I would grant you that has some independent probative value. But I don't understand what probative value it has other than proving the truth of the statement, at which case it's just a plainly inadmissible hearsay statement. I mean, I don't know if I understood the government to be defending the trial court's state of mind rationale. Are you? And I think we've made it pretty clear recently in a case called Grimes, which I mentioned because I wrote it, that is not a basis to get in. You don't get state of mind evidence in to show that the underlying statement is true. But that's the only way I understand. I don't understand the relevance of her demeanor other than as verifying that what she's saying is true. Because otherwise you could just say she was hysterical when I talked to her later that day. Good enough. Why do you need the context other than the context you wanting it to be true? I'm sorry if that's confusing.
Yeah, I'm not sure. I'm not sure. I'm not sure I quite understood the court's question. I mean, I think that.
Why does the context matter? Like the context, what does it matter what the context for her being hysterical was, unless the context is a statement, I was raped and that statement is true?
Well, I guess I think the context is important because the jury needs to know that it is related to this incident.
But
it's not that
I mean, the jury is totally familiar with the timeline, right? The jury will know from her testimony, I was raped on this night, right? Jury also knows she made a 911 call, and the jury also knows that she went to see the forensic nurse examiner. Now, these other witnesses can testify in that time frame. I got a call from the complainant, and she sounded like X. But other than the impermissible purpose that Judge Deal is positing, why do they get to say, and she told me that she was raped, that the guy had a knife, that he was African-American, that it happened on the lawn, right? Why does any of that stuff come in as context for her demeanor?
I think it's to remove speculation about what she's talking about, because I don't think that I think that the jury doesn't know, and I can see that, my argument isn't actually hitting here, but I think that it's important to know what she's talking about in order to know how this is relevant. And because the demeanor evidence itself is relevant, as Garibay says, it's admissible.
Mr. Hahn,
yes,
in Battle and its progeny, we urge trial courts and prosecutors to exercise restraint. Don't let in too much detail. Don't try to smuggle in this information for hearsay purposes. And over the years, prosecutors don't seem to be exercising much restraint. Why shouldn't we put a limit of some sort on the number of battle reports that are admissible?
I think, Your Honor, it's because, as sort of this case shows, and and other instances could show, that the probative nature of a battle report is different from circumstance to circumstance. And as the Hill case from New Jersey said, it's better left to the trial court to balance the probative versus unfair prejudicial nature of evidence in those circumstances. You can imagine scenarios where you'd expect a victim to report more times or fewer times, depending on the circumstances. And I think that that's why it's better to have that left to the trial court's judgment.
I'm just looking at Battle, and I'm sorry to drag this out.
So
the implied impeachment rationale is to explain an apparent inconsistency arising from the woman's failure at the time of the alleged rape to tell someone of the crime, when society perceives that it would have been natural for her to do so. I mean, I feel like that's satisfied once there's a single report, but I guess you want to say society thinks, although I don't know if we've ever said it, that it is also natural to tell everybody you can find and everybody you interact with. And if she had told her barber that day, you'd be able to get that in because who wouldn't tell their barber?
I think I'd push back on anybody that you come in contact with. I think that if there's evidence that she had an especially close relationship with her barber and told her barber everything that happened to her, I think actually it would count as a battle report of rape. But again, this is sort of the balancing the trial court has to do. Is this a person that we'd expect the victim to tell about the rape? I would also
posts it on social media, tells her 200 Facebook friends I was raped.
I mean, I think again, I think that it would depend on the evidence of what she would post on social media, and maybe that gets us into some rabbit holes that we don't want to go down. But that's again the trial court's balancing of discretion. That's the trial court's discretion in balancing, and that's not what happened in this case. In this case, she told her husband and she told two of her closest friends, and that's the evidence that the jury heard.
Thank you, counsel.
Yes, if there are no further questions, I'd ask the court affirm the convictions.
We'll give you 2 minutes for rebuttal. More.
Thank you, Your Honors. I think if the court has no further questions, then we would submit on our current arguments and ask that the trial court's decisions be reversed.
Did you have a page number for me? Sorry, about a record, or we can locate it, or you can submit something to the court afterwards.
I apologize about that. I do not have the page number.
No worries. I can do Control F. So thank you very much. Thanks to counsel for your arguments this morning, and the case will be submitted. And you are dismissed from the courtroom. Thank you. Just making sure everyone is here. I understand there are going to be co-counsel and or supervising attorneys present, but not visible. And I'm only seeing one box. Are we expecting anyone else?
Your Honor, I think the only person off camera is here.
Thank you. Appreciate it. All right, I'm calling the second case on our calendar this morning. It is 20 CV 363, the estate of Alexis Parker versus the District of Columbia Department of Health et al. Mr. LaCar, you were up first. If you could tell us how much time you would like to reserve for rebuttal and introduce yourself for the record, and then you can get started.
Yes, Your Honor. Steve LaCar for the appellant. Happy Thanksgiving to the court, and I would like 3 minutes for rebuttal, please. Okay.
When you're ready.
If the court will indulge me 90 seconds, I think I can summarize essentially the entire history of this case from 2010 on. The first thing is, if you choose the vernacular, this has been a game of what I'll call litigation whack-a-mole. For 8 years from the time of beginning, the District of Columbia filed its answer in this case, up to the third time around for the board. The District of Columbia's primary argument was the open competition rule prevented Mrs. Parker from reattaining her permanent career status. It's undisputed that she was returned under the Agency Reemployment Priority Program. And if you're returned under the Reemployment Priority Program, that is by definition, and I'm referring to their own regulation 2428.1, not an open competition, because they have to take your status as a career government officer into consideration. They have to hire you if you're qualified for the job, and the personnel people at the Department of Human Resources found her qualified for the job. So if by any stretch, by any means, looking at the common sense reading of Regulation 2428 of the dictionary definitions, this was a constrained competition. It was not an open competition. It may have started off as open, but the moment she showed up on the agency reemployment priority list as eligible for the job, they had to take her. They had to give her a super priority. Now, setting aside the litigation whack-a-mole, the unseemliness of their litigating this case for 8 years. And by the way, Judge Easterly, I'd refer you to your decision of Sayoum. You shall know them by their first answer, by the first position they've taken. The position they took at the time OEA went to them back in 2010 and said, why'd you let her go? What the government said twice, lovingly citing in full, was the open competition rule. There was no statement whatsoever made back in 2010, and indeed for 8 years, to this theme of what I'll get into in a second, this break in service rule. And Judge Fisher, I'll note to you that several years before Sayoum, you decided a case called DeVita versus District of Columbia. There was a traffic case, came out of a traffic appeal, but you said essentially the same thing. You look to what the decision made by the agency was, how they justified it when they were asked why they do what they did. There was no reference to this break in service rule back in 2010.
Mr. LaCar, I appreciate that, and I think we've given you 90 seconds. As I read the record in 2010 and 2011, both an administrative judge and the board incorporated this break-in service idea into their analysis. So how do you square that with your argument that the district is like a mole popping up with a new argument at the last minute?
Because Your Honor, because they primarily emphasized, okay, first, their answer said nothing whatsoever about the break in service rule. The answer was solely confined twice, in full and in quote, to the open competition rule. We litigated, well, I wasn't the trial counsel. I came in late in this case, as you're aware. The issue was briefed up at OEA. It was the break in service rule was specifically briefed very late in the case. The only time anybody really focused on this was the third time around before, and the OEA sent it back to the AJ. AJ said, take a look at Rule 816, take a look at break in service, take a look at everything. It was briefed at that time by Mrs. Parker. The third time around, the OEA judge went off solely on open competition. Then, when the case went back up to the board, Mrs. Parker briefed both open competition and Judge Fisher. She briefed the break in. She said the focus on this is Rule 816, and that.
Can you just orient me here for a second with your argument? Because you might be saying one of two things. It's not clear to me what you're saying now, and it's not clear to me what you said in your brief. You might be saying, as an atmospheric point, you know this argument is bunk because they were never really relying on it below. And that's a fine atmospheric point, but if that's your atmospheric point, I think we better get to the substance of your argument why break in service shouldn't count. Or you might be saying that they waived this because they didn't adequately make the argument below, but I don't see you making that argument in your brief. So I think you're in, are you making an atmospheric point right now, or are you making a forfeiture type or waiver type point right now?
Well, quite frankly, what I would say to you is if you want to focus on substance, it's Rule 816. All the break in service rule doesn't apply here, as we discussed in our brief.
Okay, could I just maybe get a direct answer to the question? Are you making an atmospheric point, or are you making a forfeiture type argument?
I'm saying we didn't forfeit. I don't consider this an atmospheric. We never forfeited it, Your Honor. But more.
Oh, no, I'm sorry. I was being unclear. With regard to the district's argument that there was a break in service that allowed them to run another probationary period, are you suggesting that they have not adequately raised that argument throughout the litigation and proceedings below? Or are you saying This was always their plan C or D, and that lets you know everything you need to know about the substance of their argument.
I'm saying it came up late in the proceeding. I'm not saying they've waived it. I'm saying that we didn't waive it.
Got it. Understood. Got
Okay.
it.
Let me talk about that because that's pretty important. My focus here on the break in service rule should be as follows. First of all, look at the OEA decision. They gave one paragraph analysis to that rule. Second, ask yourself this. This is what I call the 9 to 5 rule. And I'm going to sort of give you the simplified way of looking at it. Imagine, and everybody here has worked for a government agency at one time or another, large agency, small agency. Imagine somebody, you enter into a social compact, you work for the government, you know you're going to be paid less than your counterpart, but you're going to spend your career there, and you understand that if a day comes that you have to be subject to a reduction in force for a legitimate reason, that you have an opportunity to be brought back with a super priority, so long as it's not in a higher grade or a position of higher promotional potential. You will be brought back non-competitively. Now, imagine this. Your supervisor comes to you at 9 in the morning. You're Alexis Parker. You've done 21 years since you completed your probationary period. You're a grade 9, and your supervisor pats you on the back and says, "Good job, but I'm sorry, it's all over. We have to let you go." But there's good news in all this. If you can be back on the payroll by 5 o'clock, you can find yourself a position, and you're back. You're going to come back with no war. You'll be permanently reinstated. That's the government's position. And that, Your Honors, is inconsistent with Rule 816. That's what should govern this case. Now, Rule 816, you look to their break in service rule. Their break in service rule starts, it's in a section. It's in a section that talks about probationary appointments. Then you look to the more specific rule about career service employment by reinstatement. That's Rule 816. And I'm going to paraphrase. 816.1 says you have reinstatement eligibility so long as you held a career appointment permanent. Check, Alexis Parker. Your position, you weren't terminated for cause. Check again. 816.2 says if you have that reinstatement eligibility, you may be appointed non-competitively to a position at a grade no higher than the grade you last held. Check, Alexis Parker, 816.2, because she was put back non-competitively under the agency reemployment priority program to a grade 7. That was 2 grades lower than the one she held. And
Let me stop you there, Mr. LaCar. I would have said that she was appointed competitively because I understood there were 2 or 3 other people who also enjoyed ARPP rights that were applying for the same job. I think I agree with you. It was not an open competition, but wasn't it competitive?
But that's the whole key to the regulation. Open competition it's without regard to prior, it's a competition that takes place. I'm referring to 28.1 without regard to prior service. Here, once she and her colleagues entered the competition, once the other, I think it was 2 other people along with her, entered that previously open competition, Judge Fisher, it became closed by definition because one of them had to be selected. So no, it's not an open competition as I read that regulation.
So help me with this. What does reinstatement mean? I note that the regulations use the term reemployment, and sometimes they use reinstatement. What is the essence of reinstatement?
Well, let me hearken you back to the 1964 civil rights laws and all the employment discrimination laws that have happened since then. Reinstatement means you've come back to where you were before. It's like you're back where you were before without prejudice. And in the government.
So if you'll excuse me, I understand you to be saying it is not legally possible to reinstate someone and at the same time put them on probation unless they fit within one of these exceptions in 816. Is that correct?
I think that's right, and I think we can gain some comfort from that as follows. In the government's brief, and I filed a supplemental authority to this, the government said you should analogize in some respects to federal personnel services law. At the time Home Rule came into effect, we both know it was created out of the District of Columbia was governed by the federal government. One presumes that the people who drafted these regulations were perfectly conversant with the federal system. And as I stated in our supplemental filing that we submitted to the court a year ago, back in January, earlier this year in January, we pointed out that in the federal system, at the time these regulations came into effect, and by the way, these regulations have no explanation. The government, they don't really, there's no preamble that really defines what they're saying. But in the federal system, if you were a career servant, civil servant with tenure, and you were let go, and it was let go as part of a RIF, not let go for cause, you had absolute right to be reinstated. And that's part of, again, what I call the social compact. You assume that people are going to make a career in government. They're not going to get paid. They're not going to get paid, Judge Easterly, what other people make, but they're going to have some comfort in knowing that for a 2-year period, they're going to have a super priority right, and for a 3-year period, they'll have a right to reinstatement if a reduction in force has occurred. In the Washington Teachers Association case, this court said quite plainly, it recognized the city council had a desire to have reemployment priority programs. What is a reemployment priority program? But for a program that gives a super priority to somebody who has gained tenure. And she's not gaming the system. It's undisputed that she came back in a lower graded position. She went out at a grade 9, and when she was returned, she came back as a grade 7.
Mr. LaCar, will you discuss for me the difference between reinstatement eligibility and reinstatement entitlement? You seem to be arguing for entitlement.
I think you're entitled to reinstatement under certain conditions. You're entitled to be reinstatement without competition and strike that. You're entitled to be reinstated and to have your permanent status restored if you comply with Rule 816.1, 816.2, and 816.5. And I think
where do you see the word entitlement or anything that's a synonym for entitlement?
Sure, 816.2 says you may be appointed non-competitively to a position at a grade no higher. Then it says, look at 816.5, a person who is reinstated under 816.2 shall be given permanency. Shall, isn't that mandatory? I think that.
Well, 816.2 uses the word may, which you just repeated. So that doesn't sound mandatory to me.
Well, but Your Honor, sometimes regulations can be read in such a way, and I think that's the district's position, but it produces a perverse, or what I'll call
You're not actually arguing with Judge Fisher on the fact that if under 816.1, you start with eligibility. Am I correct with that? What I hear you saying is if you proceed through the process, someone who is eligible, but then gets appointed competitively or non-competitively under 816.2 and gets reinstated, at that point, they have this entitlement to the career appointment, parentheses, permanent, which is then defined as someone who's completed their probationary period.
That's correct. Your Honor. Look at it.
So the entitlement doesn't start with 816.1. It's only when you've progressed through these various phases.
As I said to Judge, that's correct. I'm sorry, I didn't mean to cut you. If you look at 816.5, let's think back for a second to a common principle of statutory and regulatory construction. The specific controls the general. To the extent there is any ambiguity in 816.2, 816.5 says if you're reinstated under the provisions of 816.2, ye shall be given a permanent appointment. It says shall. That's mandatory by anybody stretching the imagination. Imagine, if you will, this concept the government has that you've got that the break in service regulation means you've got to find yourself a new job in 24 hours. Where has that ever happened in history in any bureaucracy? It produces an anomalous result. So you have this entitlement. You have this social compact, as it were, what they call incentivizing in the most recent regulations. As I said, that kind of carries forth the thrust of what I'm arguing. There's this compact that you have. You know you're not going to get paid as well. You're going to have interesting work. You're going to enjoy what you do, hopefully. But if that day ever comes that they have to have a reduction in force, you are going to have some comfort in knowing that as long as you're not gaming the system or taking advantage of the system, that you're going to have a super priority right to return to a job that personnel finds you qualified for, so long as it's within the time constraints of the agency reemployment priority rule or the citywide reemployment priority rule. It's that simple.
But the government argues, and Mr. Phillips will correct me if I'm mangling this, that under 816.3, your entitlement to priority placement under Chapter 24, I guess it's 2427.5, comes first, right? And that then this 3-year, it's called a restriction, but it's really kind of an add-on, comes after. So what's your response to that argument?
Well,
And maybe I've misrepresented the argument, and Mr. Phillips will tell me that I messed it up.
I don't think you've misrepresented. My response is, how many angels can dance in the head of a pin? The bottom line response is, you have a 2-year period to come back to your old agency. If you don't make it within that, you get that super priority. If at the end of that period, there's still, or you can go elsewhere to another agency during that time. They run concurrently. If you don't make it to your old agency under the reemployment priority rule during those first 2 years, there's another year that maybe a city agency, another agency will pick you up. But we don't have to focus on that. The focus should be, what did they admit she was reinstated as?
Can I just make sure I understood? You said that the 2 terms run concurrently, so
I think they do. I
the
think
period under 816.1 and the period under the 2-year period under Chapter 24, but isn't that in tension with the actual language of 816.3, or am I really not understanding this?
I think you're understanding. The problem is these regulations are not well drafted.
I mean, if you were pointing us to shall language in 816.5, but 816.3 also has shall language that seems pretty clear that the, if you're separated by a RIF, that 3-year period of priority placement shall start on the expiration of his entitlement to priority placement under Chapter 24. So it seems like it's saying it's sequential, not concurrent.
But you have a 2-year period. You have a 2-year period. That's all I want to focus on. I want to focus on, what was she reinstated under, Your Honor? They agreed, they admitted in their answer that she was reinstated under the agency reemployment priority rule. That's the Department of Health, where she worked for 23 years. That's in their answer at supplemental app paragraph 5. If she came back under the agency program, and she came back within 5 months, that's well within the 2-year period, then under 816.5, they had to give her a permanent reappointment. She successfully completed probation 21 years before, and she rose to a grade 9 and was going back to a grade 7.
Mr. LaCar, a couple of questions. Am I understanding you correctly that you think Section 813.8, the break-in service provision, simply doesn't apply in these circumstances?
Yes.
Okay. I had thought that in 816.3, you were focusing on the word restriction and analogized this to a tolling of a statute of limitations. Did I misunderstand?
It's hard to analogize. Well, the way I see it, the regulations are inartfully telling us that you have to come in the government and you're going to serve a probationary period. That's the 813 regulations. Then the 816 regulations tell us what happens if you're going to come back by way of reinstatement. If, heaven forfend, something has happened, so long as you're not terminated for cause or you don't leave voluntarily.
I get the point. A factual question or a record question. Is there anything in the paperwork that led to her reemployment that indicates that she was reinstated as opposed to hired again?
There is indeed, Your Honor. Thank you for bringing that up. The form 50 that is in the I believe it's actually in the supplemental appendix. The form 50 specifically has a service computation date in block 31. And if you take a look, I'm hardly looking for it.
I understand what you're referring to. You're saying that they should have deducted 5 months for the break of service if they were not in fact reinstating her.
Right, that's what they're saying. They have a service. Oh, it's supplemental appendix 23. They have a service comp date is 1/30/1987. That's when she came to the government. Their actions, their contemporaneous actions, belie the position that they're taking here, Judge Fisher. All the way through, the personnel people treated her as if she never left the district government. From the time she came back on that so-called probationary appointment, up to the point of time that they actually they terminated her a second time, she's listed as having a 1987 service computation date. She's treated as if she were there all along, and that's consistent with the regulation, in particular 816.5. I'm sorry. So, well, let me also point this out. The concept of reinstatement is make whole, and the regs control for anything. The Reg 816 should be deemed to control anything that has to relate to the start of employment. That's the Rule 8, that's the 813 regulations. Again, DC came out of the federal system, and it's been federal law since 1968. Home rule was a few years after that if you were a federal employee who completed a probation and you came back in a lower grade position or a position no higher than you held before, that you were given back your tenure. It doesn't make it produces an anomalous result if you can't find another job under their theory between the time they hand you your RIF papers and the close of business that afternoon. I mean, she didn't game the system here. This is the woman who invested her career in the government. And she was I'm sorry, Your Honor.
I was just going to say, I think we have your argument, Mr. LaCar, in case, unless my colleagues have any other questions for you at this time. And I think we'll hear from the government now, and we'll hear from you again after the government.
Thank you.
Thank you.
Good morning, and may it please the court. Graham Phillips on behalf of the Department of Health. I'd like to start by zooming out and explaining our view of the big picture in this case and how the court should walk through the decision tree here. And I recognize that this is litigation with a long history and that a lot of issues have been briefed here. But I think in deciding whether to affirm the OEA board, this court actually needs to answer just two questions, both of which I think turn out to be easy. The first is, did Parker establish before the OEA that she had been reinstated under Section 816 of the personnel regulations? The answer to that is no, for any of the three reasons that we spelled out in Part 1A of our brief, the details of which I'm happy to delve into in just a minute. But to keep with the big picture, I think so long as the court agrees with any one of those reasons, then the only question left is whether Parker had a break in service that triggers a new probationary period under section 813.8. And the answer to that question is even easier. Yes, she definitely did. She had a break in service of more than 5 months. And so I think if the court answers those two questions, was she reinstated? No. Did she have a break in service? Yes. That can and should be the end of the court's analysis. And the court does not need to get into the question of open competition under section 813.9.
Can you explain to me what the point, what function 816.5 has, where it says a person reinstated under 816.2 shall be given a career appointment if any break in one day is sufficient to obviate that protection?
Sure, and the answer is it does not. And this is a point, Your Honor, that we conceded in our brief, that if you're in a situation where there has been a reinstatement and there has been a break in service, which effectively there always will be with a reinstatement, that 816.5 controls. And if those are the only two things at play, then you would get permanent status.
Okay. And this wasn't a reinstatement. I take it you have two different reasons. Tell me if I'm mixing these up. One is that she wasn't yet eligible for reinstatement. Is that one of your reasons?
Yes.
And the other one is because when they filled out the checkbox form, they checked hired instead of reinstated or something like that, right?
That's right. That as a matter
so
of
these protections under 816, in your view, if assuming somebody is eligible, are entirely at the election of the government.
That's correct, Your Honor. And I know that might initially seem strange, but I really don't think it is. So
okay.
For one thing, just as a sort of textual matter, there's nothing anywhere in section 816 or any other regulation that ever makes it mandatory to use reinstatement as the mechanism for rehiring someone. And
I don't know. Let me push back on that for a second, because 816.2 says they may be appointed competitively or non-competitively, either one. I mean, the permissive there refers to two alternatives, and obviously it's not requiring you to appoint somebody. So I don't see that as being quite so permissive as the district does. And then if you look at 816.5, it says if a person is reinstated under the provisions of 816.2, the only thing 816.2 refers to is an appointment. So any appointment under 816.2 qualifies as a reinstatement under 816.5, I think. And that's what am I getting wrong in that? That if you are appointed once eligible, then reading 816.2 and 0.5 mean that you have been reinstated.
So I agree that 816.5 is mandatory in terms of what is the result if you are reinstated. But 816.5 doesn't compel anyone to be reinstated. And I think the federal analogy here is useful, Your Honor, because
I guess just to stick on this topic, because I find it a little bit of a vexing one. I don't mean to belabor the point. I just really have a difficult time with it. But 816.2 only when it refers to it doesn't say a person may be reinstated competitively or non-competitively. It says they might be appointed competitively or non-competitively. And then 816.5 says a person who is reinstated under. I take it you're saying 816.2 can allow an appointment of two different types: a reinstatement, but then it could, that can't be, because you're only allowed if you're reinstatement eligible to be appointed under 816.2. So it wouldn't make any sense to have 816.2 apply to anything other than reinstatement. Does that you're ahead of me? So please explain where I'm getting confused.
Well, no, I think you're right that 816.2. So 816.2 says there are two. This can be competitive or non-competitive. So but either one of those, we agree if that either one would be a reinstatement if the agency is invoking reinstatement as the mechanism for undertaking this rehiring. But it doesn't have to do that.
Okay, and you were gonna explain to me why that. I'm sorry, I didn't mean.
I would like to jump in here and say, so where are the regs about what happens if the agency opts not to go reinstatement? Like, this argument seems to be made out of kind of thin air, right? Like, I mean, you're picking up on some ambiguity perhaps in 816.2 and then saying this other alternative exists, but where is that other alternative actually discussed?
Well, the other alternative is just the general rules for hiring people into the district career service. So for example, everyone agrees that if I worked at an agency for 10 years and then I decided to leave and I was out of government for 3.5 years, and then my old position came up and I applied for it and I got hired again, I was rehired by the district. Everyone agrees that would not be reinstatement.
Right, no, but I get that, but it's just within the 3-year period. This is a highly regulated area, right? And there are lots of regulations about it. And so if you thought that there was some sort of escape hatch for reemployment, but not reinstatement, you'd kind of think that there might be some regulations that talk about that and say, you know, you need to make sure you give the employee notice that that's what's going on at a minimum, right? It seems like the whole point of this is to give protections within this time frame. And if the employer, the agency can opt out of those protections, you'd think that the regulations would say something about that, and they don't. In your example, if you're outside of the 3-year window, well, the regulations speak to that. They say this only gives you protection for this period of time, but you're talking about within the window. And so the silence is kind of curious.
So I guess I have a couple of points, Your Honor, but one, I would like to invoke the analogy to federal practice, because I think my friend on the other side has agreed that this is useful here, and that the federal system, the sort of regulation governing reinstatement, has long predated the district one. And it's well established in the federal context that it is discretionary, that someone who has a reinstatement eligibility and is rehired, that the agency has the discretion to effect that rehiring sort of through normal competitive practices or through reinstatement. And it's the agency's discretion. And if they choose not to use reinstatement.
And if I go and look at the federal regulations, will they be equally silent on that score, or will they actually explain that it's discretionary?
Well, they say, analogously to 816.2, that someone may be reappointed. May be reinstated. So the discretion just is in the word may under the federal regulations. But that's a sort of a long settled fact of the federal practice, that it's in the agency's discretion. And I want to say that I can understand how it might seem weird. Why would an agency ever do this? Why would they ever sort of agree to reinstatement if it's discretionary in the way I'm saying? And the answer is that, you know, the district has to compete for high quality candidates just like anyone else. And this is a sort of a tool, that a way to give benefits to, you know, strong candidates who they want to come back into district service.
Mr. Phillips, it strikes me as worrisome to think that this is completely discretionary without any guidance. For instance, I could see a system which says, if you're going to elect to rehire somebody but not reinstate them, you have to make that clear on the hiring forms. And in considering how to exercise your discretion, you will look to the following factors. But here it just seems to be, are you in a grumpy mood today? And if so, then put them on probation, don't reinstate them.
So it sounds, I understand that it does seem like it could be very wise to sort of cabin discretion if you have some concerns about agencies, you know, sort of being unfair in how they use this tool or not. I don't think we have any evidence that there's been any kind of abuse to the extent that that concept makes sense. But again, I think agencies are disciplined to some extent by the fact that, you know, this is a tool they're going to need to use when it's useful to sort of get good people to come back into district government. And
let me return to a point you made a while ago, which I think had to do with burden of proof. I understood you to say Ms. Parker had the burden of proving that she was reinstated. And you say that because it's a jurisdictional question? Is that right? Or why do you say that?
Yes, that's right, Your Honor. Under the OEA's rules, the applicant has, the employee has the burden of proof to establish the OEA's jurisdiction. And here, that jurisdiction turns on whether or not she was probationary, and that in turn turns on whether she was reinstated. So I do think she had the burden of proving that she was reinstated. But I think that's right, but I don't think who had the burden would matter, because I think the evidence is completely one-sided. There is no evidence that she was.
You should have listened to Mr. LaCar. He points to the service computation date.
Your Honor, I would
not one-sided.
I would be happy to address the service computation date, because I'm afraid my friend just has a mistake of fact about what the record shows. So if you look at supplemental appendix page 23, that is the SF-50 from when Ms. Parker was separated through the RIF. And it says that her service computation date is January 30th, 1987. Then if you look at supplemental appendix page 40, that is her SF-50 from when she was rehired in February 2010. And there you will see that the service computation date has changed. It is now July 14th, I believe, 1987. So the service computation date has shifted by 165 days. It's shifted by 165 days because that is the exact length of time between when she was separated through the RIF and when she was rehired in February 2010. So that piece of evidence, far from suggesting that the agency treated her as if she never left, is further confirmation that, in their view, she had a break in service.
If I understand the repeal of the regs and the new regs correctly, this provision, I guess it's 816.3 about the 3-year restriction, that no longer exists. Is that correct?
Yes, I believe that is correct, Your Honor.
Nevertheless, the Superior Court relied upon that. Is there any reason we need to or should address that question given the repeal?
I don't think you need to address that question, because I think we can and should win for sort of easier reasons that you should get to first.
Let me press you. Assume you lose on the others.
So, I mean, I don't think you can treat that change as retroactive and say that.
I'm not saying that, but let's assume that I flat out disagree with what the Superior Court said. Should I bother to comment about it since that provision no longer exists?
Okay, yes, I understand. So, I mean, I certainly don't think that there's any sort of reason in terms of this court's function as law clarifier to do much clarifying about provisions that are now repealed. So in that sense, I don't think you need to, because I think there are two easier ways to decide that she was not reinstated that would allow you to avoid talking about 816.3 entirely.
So open competition is not one of them, in my view. Persuade me otherwise.
Sure.
This was a closed competition because people who had not previously worked for the government had no chance of being hired.
Sure, I'm happy to dive into that, Your Honor. I just would like to put a pin in the argument about reinstatement, that I think there's the whole issue of forfeiture, which we haven't discussed, which I think that's another way. But setting that aside and hoping I can return to it, let me talk about open competition. And let me acknowledge, I understand the sort of counterintuitive nature of thinking that this was an open competition, but I really do want to try to persuade you. And
excuse me for interrupting, but as you're persuading me, please incorporate this question. I can read English, and it seems pretty clear to me. However, the OEA read this differently. do I need to defer to their reading, even if I think it's wrong?
Well, I mean, I think you should defer to it in the sense that, this is an agency that's entitled to deference when interpreting these regulations generally. But I agree that deference always is subject to a court's conclusion that the agency's interpretation sort of runs contrary to the regulations that it can't be sustained. So I'm not trying to claim that you sort of are bound, to give a sort of insurmountable deference. It's the normal deference, and if you agreed that the text can't bear that interpretation, then we would lose. But I hope I can persuade you otherwise. And so I think the sort of the key point I'd like to get across in talking about this today, and to sort of put before you and see if if this helps sort of explain the larger framework, is that I really think open competition, whether a hiring process is open competition, is a determination that has to be able to be made on the front end when the agency sets the process in motion, and not depend on a kind of ex post, after the fact analysis of who actually wound up in the candidate pool or was hired. And I think the reason that it has to work that way is that there are various places in the larger regulatory scheme where the regulations say that an agency must use open competition to fill certain types of appointments. And because they have to use open competition, I think they need to know, as they go into it, that they have started the process that will count as open competition, and not have it sort of be knocked out of open competition after the fact. And if you'll indulge me, I have an example that I'd like to just walk through to sort of flesh that out, that I think is useful and sort of needs to be grappled with. So there's one type of an appointment under these regulations called a term appointment. And that's for a job that will last between 1 and 4 years, a time-limited position in that way. And it's governed by Section 823 of the old regulations. And 823.4 says that term appointments at grade 13 or higher shall result from open competition, except in the case of a candidate who's eligible for reinstatement. So imagine an agency that needs to fill a term appointment, and there is no one with reinstatement eligibility who's qualified for it. In that situation, 823.4 tells the agency you have to use open competition. So then the agency will do what the Department of Health did here. It will post a job that is open to all applicants, whether or not they've ever worked for the district government. But now suppose it turns out that there is someone out there who is qualified for this position and has priority rights under the agency reemployment program or the displaced employees program. So in that situation, we sort of find ourselves under Parker's view of open competition, we find ourselves in a paradox. Parker would say that the fact that we now have a qualified person who's priority eligible, that means on his view on her view that this is no longer open competition. But under the ARP and DEP regulations, you do have to give that person priority. The priority rights apply to term appointments, just like any other.
I understand your practical argument. Could you tie it to the wording of the definition of open competition, which seems to go further than the front end and talk about consideration of all persons without regard? So it seems to incorporate the decisional process as well as the advertising of the position.
Yes, Your Honor. So I do think maybe one way to conceptualize the dispute between the parties here is about, does this phrase, without regard to current or former employment with the district, does that phrase modify, is it sort of focused on modifying consideration? That I take it is Parker's view. And that if it turns out that the consideration has, that in the process of considering, you've looked at and given any kind of weight, I think, to their prior district employment, then that knocks you out of open competition. And my reading is that instead that phrase is focused on modifying all persons. It's telling you that it has to be that application and consideration has to be allowed for all persons, whether or not they have ever been a district government employee. And you know, a big part of the reason why I think that is right is because
I just think it would say, the language would be different. It would say all persons, whether or not they have had, right? I mean, without regard seems to modify just grammatically use of examination procedures which permit application and consideration, right?
I agree, Judge Easterly, that they could have written it differently, and maybe they should have. But I do think, for one thing, the language that it's actually closest to is all persons. It comes right after all persons. But I mean, I acknowledge that there are multiple ways to read it, but I do think if you read it in the way on Parker's reading, where then you wind up basically saying that nothing will ever count as open competition, because I think on Parker's reading, open competition exists only if the agency is allowed to ignore the fact that someone had prior or current district employment. And I don't think the agency,
No, it's not if they are, is that right? It's just, if those people don't show up, right? Then it's open. But if those people show up, it's not open anymore because those people get priority and their priority should be considered.
I think there are maybe two problems with that, Your Honor. The first is about the text of the definition, and the start of the text of the definition is it's about examination procedures that permit. So the question, I think that framing is about what do the procedures allow, not what after the fact turned out to happen, but what do they allow? And the other problem again is that if it's the case that this type of scenario comes along and knocks a hiring process out of being open competition, then you do get into these paradoxical situations where some parts of Chapter 8 have told you you need to use open competition to fill this appointment, and yet the priority regulations tell you you have to give this person priority. And you know, in that situation, on this reading, there's no way for the agency to comply with both. If they have to give the person priority, but if they do so, on Parker's view, this is no longer open competition, but they have to use open competition.
Does that matter anymore? Hasn't the definition of open competition been changed under the new regulations?
It has, Your Honor. Yes, it has. So I mean, I agree. And also the sort of the analog to section 813.9, which is the provision, you know, that's at issue here, that again, I don't think the court needs to get to, but that provision, the analog to that provision in the new regulations is also different.
So this dilemma that you're telling us about has now evaporated with the change in the definition of open competition?
I don't know that it is. Sorry, I don't know that it has. Because I think there are still, you know, for instance, I think the same, you know, term appointments, again, I think the regulations tell you you have to use open competition, and yet you still have to give priority. If someone with priority comes along, you have to give them. So again, if that knocks something out of being open competition, we wind up in these situations where it's impossible to comply with both sets of regulations.
But my question, I guess it's not a point because I don't remember the words. My question is, since open competition is a defined term, hasn't it now been redefined to remove the language we've been focusing on about without regard to previous employment with the district?
Yes, you're correct, Your Honor. It has changed. And I'll confess, I don't, you know, I haven't sort of thought through all the implications of what that could mean in cases under the new regulations, in part because I think the parties here have agreed that this case has to be governed by the old regulations.
Right.
But I, you know, if I guess
just finish. I'm sorry. Can you finish the paradox argument that you had with 823.4? Because I actually read it as being inconsistent with your argument, so I want to make sure I understand your point.
Sure. I think that the paradox is just if you get in a situation where the agency is trying to hire someone in a category of appointments where they have to use open competition.
Right.
But there could be someone who's applied for that position who is
Right.
entitled to priority consideration. And on Parker's view, the fact that they're in there and they're entitled to priority consideration means that this is no longer open competition.
That complies with 823.4 because it says, except in the case of a candidate who's eligible for reinstatement. Okay.
Yes, Your Honor, but there can be, and this is a useful point to make. You can be entitled to priority consideration under the ARP and DEP programs when you are not entitled to reinstatement eligibility. And that's true, setting aside the parties' dispute here about the 3-year period, because you are entitled to the priority placement benefits, even if you were separated by a RIF while you were still on probation. You only get them for 1 year in that situation, but you are entitled to priority placement and the displaced employees program, which sort of brings me back to a point I really want to emphasize, which is that being hired with the advantage of these priority programs, that does not mean you were reinstated under Section 816.
Would you focus on the language of 813.8, please, which includes the break in service provision?
Yes. So
Do you agree that it does not require the district to put the newly hired person on probation, but really only permits it?
no, I think if there has been a break in service, and if there's sort of no other regulation that's coming into play, it means that yes, you do have to. They do go on to a probationary period, and that it's not permissive.
Do you have the language available to you?
Yes.
I'm focusing on the word shall not. This is a general prohibition against a new probationary period, except in the case of a break in service. That to me always adds up to saying it's not prohibited if there's been a break of service, but I don't see any shall language.
Well, I think, Your Honor, that, well, two things. One, I think the parties here have both agreed that that is the meaning of 813.8.
You can't persuade me by agreeing contrary to the plain language of the regulation.
No, I understand, Your Honor, but I think the sort of my fallback point here is that I also think that the sort of really 813.8 is itself an exception to the general rule that when you're appointed to the career service, you're probationary. And then 813.8 is sort of saying there can be exceptions to this, such as when there is no break in service. But if there has been a break in service, then I think the truly baseline rule of when you get appointed, you have to serve a probationary period comes into play. And I think that's why the parties have never disputed this point throughout this litigation, that if there's a break in service and nothing else is at play, then you do go through a new probationary period. Maybe while we're on the topic of break in service, I can just address a few more points about that. So I take my friend on the other side's primary argument to be that this break in service issue sort of has come up too late. I don't think that's right. And I think, in fact, if there's been any forfeiture on this point, it's on Parker's side. The board talked about the break in service as far back as 2012. It was clearly sort of raised as an issue and testimony taken on it during the hearing before the administrative judge and to the OEA board. And at neither point did Parker argue that this is somehow impermissible for this issue to be raised. And likewise, nothing in Parker's opening brief to this court says that the consideration of break in service by the administrative judge or the board was improper. Sorry, I'm just making sure I touch on my notes here. I guess a couple other things I'd say is that there's just nothing absurd about the break in service rule applying here. There's nothing in the priority programs guarantees anyone a non-probationary appointment. That's just not part of that program. It's a hiring preference, and it's a powerful one, but it doesn't, by its terms or by any sort of implication or necessity, guarantee someone a non-probationary appointment, which is true of other hiring preferences, things like the veterans preference or the district residency preference. They don't give you a non-probationary appointment. So there's sort of nothing absurd about there being a probationary period here. I guess I'll just end that I think the easy path through this case is that the first question is, was there a reinstatement? And I think there clearly was not, as a matter of fact. But again, I do think this whole issue was forfeited because it wasn't raised before the OEA board. And I think it would be very, the OEA board's decision discusses reinstatement not at all. And the reason it doesn't is because the petition for review doesn't sort of contest the administrative judge's analysis of this issue. So I think it would be pretty strange and frankly a little unfair to the board to sort of throw out their decision as arbitrary and capricious on the grounds that they didn't address a topic that was not raised. And then once reinstatement is out of the way, the question is just, does the background rule of the break in service come into play? And I think it clearly does. And that can be the court's the totality.
And reinstatement is purely at the government's election, but that's not weird because they'll do it sometimes for competitive advantage. And it's not provided for in the regulations because it just goes back through the new employee set of regulations, although they left that a little cryptic.
That's right. It just if reinstatement doesn't apply, then just the sort of regular procedures would apply as they would to someone who gets rehired 3.5 years after they leave district employment. Who would, I think it's undisputed, that person would have to serve a new probationary period. And that would be true even if they, were the world's most, stellar performer in their prior employment with the district. I think it would still apply, and it's not absurd for it to apply. If the panel has no further questions, I know I've gone well over time, and we would ask that you affirm. Thank you.
We led you over time. So thank you for answering our questions. And now we'll hear from Mr. LaCar. Just a few minutes to wrap up, if you would, please.
Thank you, Your Honor. One thing we made quite clear in our supplemental filing that ever since 1968, and we cited it, if a federal employee who has completed probation is subject to a RIF and they're brought back under a reemployment priority rule, they are to be given back their permanent status. His claim that it's discretionary is simply inconsistent with the rule. Now, Rule 813.8, I'm not saying it's abhorrent. I'm simply saying it's utterly irrelevant. It wasn't really litigated until the very end of the case when the board suddenly picked up on it in a one-paragraph decision. Guidance, Judge Fisher, you were suggesting some guidance, and the Form 50s that are reproduced at Essay 40 and Essay 47 have Ms. Parker of a service computation date going back to 1987. The concept of open competition, I don't want to disabuse you from your correct reading that this is not an open competition, but as I sat here, I just pulled open my Webster's dictionary. Open competition, free, not open, free and unrestrained. This is a constrained competition. Mrs. Parker had to be taken. So we begin with the fact that the federal rule has always been, at times since home rule, that if you were taken out of a job in a RIF and you had already completed your probation period, you were entitled to come back in your as a permanent employee, not discretionary, like he says, entitled. This is Rule 816.5 all the way. Questions were raised about jurisdiction. I concede that the employee has to establish jurisdiction. The problem that the government's position is, it skips over something. We did establish jurisdiction. We all the way, we argued for the application of Rule 816. It was the board, and it was the board, first of all, it was the AJ who consistently misread the open competition rule, which Judge Fisher has correctly read it the way we see it to be. And lastly, it was the board that came up with this concept of the break in service rule in a one paragraph, ipsy dixit, no reference to precedent. Our argument is 816.5. It's mandatory. It's not that hard.
You know, I think if I understood Mr. Phillips right, maybe he could nod or shake his head, but I think I think you and he agree that if this was a reinstatement under 816.5, then 813.8 doesn't matter. I think, thank you, Mr. Phillips. Which you know, I think is quite helpful because I didn't totally have my head around that coming in, but it sounds like, you know, kind of where the rubber hits the road here, in my mind, is whether or not reinstatement, whether or not we can read 816.5 and 2 to mean that reinstatement is sort of a discretionary decision at the agency. And I'm just not sure how much I can glean from the regulations about that. I suppose your reaction is, well, these protections mean nothing if it's just whenever they want to reinstate, they can, but they don't have to. And I suppose his reaction is, well, there's competitive advantages to doing it and other reasons. I find that a little bit vexing. If we're sort of, we owe some deference to the agency on that, on reconciling these provisions, or this doesn't quite sound like what the agency reasons, so I'm not sure.
Well, we don't read regulations in a way that gives them an absurd result. That's Tippett versus Daly in a line of cases going back to time immemorial. Their reading does give 816.5, 816.1, 816.2, and 816.5. It makes them superfluous. Everybody here agrees. Everybody agrees that she was reinstated under the agency reemployment priority rule. And under Rule 816.5, having completed probation, and most importantly, coming back in a lesser graded position. She didn't get any benefits. She came back in a lesser graded, well, she did get a benefit. She was returned on a payroll for a short period of time. She's returned in a lower grade position. That is a prime example of what I'll call the beneficial application of Rule 8 of the Agency Reemployment Priority Program. Their reading juxtaposes the break in service rule in an area that it's not intended to apply, and it produces what I call an anomalous result, the 9-to-5 rule. You better get back on that payroll.
Please clarify, Mr. LaCar. Is there anything in the agency reemployment priority rules that speaks to this question of probation? Or do you get your argument by looking next door to the general regulations governing reinstatement?
I'm sure going to say, I'm going to say you get it from the general regulations, but if I don't have the answer off the top of my head, for which I apologize to you, I rarely am that unprepared. I would submit a supplemental 28K letter. I think you get it off 816, but I'll look at the, let me hurriedly look at the reg.
I've always known you to be well prepared, but
well, this may be a time that I'm
I
not.
just wanted to clarify, since you're emphasizing the agency reemployment priority rules.
Well, that's why she came back. That's how she came back under that program. They had to take her, and the Rule 86, Chapter 816 tells me pretty clearly that if you're bringing them back under reemployment priority rule, that and they've done probation and are now coming back in a higher grade position, you have to give them back their permanent appointment. Why else would you destroy the incentive to have civil service? Why would you destroy the incentive to have civil service employment to begin with? Why
Got it.
why would the agency want to divest itself of the expertise of somebody who'd worked there, who came into work and worked on the implicit understanding, actually not so implicit, I'd say the express understanding that if you come back, we're going to have a slot for you as long as you're not benefiting from this. And she certainly didn't benefit from this. That's what I have, Your Honor.
Thank you, Mr. LaCar. Thank you, Mr. Phillips. We appreciate both your arguments today. This case will be submitted and you are dismissed from court.
This honorable court is now adjourned.